good evening, everybody. I hope you're all having a good day, good week. Today's obviously Thursday. I normally do this on Wednesday. Had something with actually my wife and I and some friends went to see a play at the local community theater. We saw Music Man, which was really good. If you've never seen it, it's really worth watching. Very entertaining. It had a really nice message. So we had a nice time with that. And so obviously I couldn't do this last night, but I'm here tonight. So I hope everybody is enjoying. Well, hopefully we'll get something out of this as well. And maybe we'll see some new faces. So let's kind of get right into the questions. GI Jose, who's been here before many times, asks, if my banking information changes before decision, should I notify SSA right away? Would I have time after the award letter to notify? I would tell you to notify them as soon as you possibly can. Social Security gets really backlogged, and details like banking information, it can be real easy for that to get lost in the shuffle. So I would not wait on that. In fact, I would notify them, probably multiple times, and continue to follow up to make sure they've got the right information, because I've had situations where I'll send them something, repeatedly. They'll ask for my fee agreement or my appointment of representative form. We'll submit it 5 or 6 times electronically. This is not, by fax, or this is not in person. This is electronically. It should go right in the file. They managed to lose it. So I would tell you to submit often and just continue, 3 or 4 times until you've confirmed that they've actually got it. I even have a situation now where I did a contract hearing for another group, not a law firm, but a insurance, kind of a company that does work for insurance companies, and they had me do a hearing on their behalf. And so they're located in Florida. Somehow or another, my name and their address got associated. So I had a case where I won the case. My client got paid. I never got paid. I call up, oh, we show the check was sent to this address in Florida, and they got it in Florida. They sent it back. Of course, nobody did anything. So I'm still trying to get that money. I mean, it's crazy. So I would tell you, submit your change of bank information, at least 2 or 3 times, using different methods. Do it by phone, do it in writing, do it by fax, but don't be surprised if it doesn't get caught the first time. Okay, another question from Jose. On average, how long does an ALJ, administrative law judge decision take? I would tell you that it can take anywhere from, excuse me, it could take anywhere from about 3 or 4 weeks to 3 or 4 months. And there's no correlation between how long or how quick you get it and whether you win or lose. I've had cases, and I would say this, usually a fast decision is a positive, although not always. Usually, but not always. A slow decision, which might mean, 2 or 3 or 4 months, there's no correlation between winning and the speed of the decision. The reason for that is that the decisions are written by decision writers who were not at the hearing. They're in a centralized location. I know at one point they had a group of writers in Maryland. And so if the writers are behind, your decision gets delayed. So there's no, I would say 6 weeks to 3 or 4 months is pretty typical. If it goes longer than that, it's probably because there was going some back and forth with the judge. I did a podcast episode. I've got a podcast, as you may know, called SSD Radio, which I need to really update. I've got a couple episodes in the can. Have not had a chance to update it. But I interviewed a gentleman named Spencer Bishens, and Spencer used to be a paralegal, or actually a lawyer with Social Security, and he was a writer for some cases. And I also interviewed a gentleman named Cameron Khanna. Cameron used to work for me. He became a writer, and they both talked about the process where the judge would make notes. It goes to the writer. The writer then, reviews it, drafts a decision. Sometimes, according to Spencer, the writer might go back to the judge and say, I think you made a mistake here. And it can go back and forth. So it can go back and forth 2 or 3 times until the judge is happy with the actual decision. All right, Jose's got a lot of questions here. These are good questions. Do you find it easier to argue functional capacity over jobs in limited numbers, than the economy with a vocational witness? Yes. Well, realize functional capacity is one of the 3 theories of disability that you can win by arguing that you meet a listing, Usually those are caught early. Those are typically cases approved at initial or maybe recon, occasionally at hearing, but usually those are caught early. Those are really serious conditions because the listings, and I've got a website called metalisting.com. If you want to look at the listings, Social Security makes really, really difficult to meet those listings. So I would tell you that it's pretty rare to meet a listing, in general, but if you're going to meet one, it's because you've got something really, really significantly wrong, and it'll be done, again, fairly early on. That's theory one. Theory two, or argument two, is the grid rules, and we've talked about that a lot. Go to gridrules.net if you'd like to see the grid rules, how they work, and some examples. That's basically for people over age 50 with a physical limitation. You cannot use the grid rules for depression or anxiety or any sort of a non-physical problem. But if there's a physical element to it, and typically musculoskeletal issues, back pain, knee pain, things like that, the grids would apply. And the grids basically change the definition of disability for those over age 50 in certain circumstances. So if you, and realize the grid rules were written for construction workers who were over 50 who can't work anymore. That really don't have any other transferable skills. That was kind of the thought behind it. And it's been expanded to apply to really just about anybody. A lot of people think, well, if I've got a college education, the grids will not apply. That's not the case, because a lot of times in the grids, if you look at them, one of the questions is, are there transferable skills? And if you have pain or fatigue or medication side effects, nausea, things like that, that can be used, even though they can't be used directly on the grids, they can be used to eliminate transferable skills. Because if you have, let's say, the skill to do an inventory or the skill to manage people, but you have a significant amount of pain or you're nauseous, you're not going to be able to maintain sufficient attention to do it. So you get rid of those transferable skills by arguing against, that you've got pain or nausea or something like that. So the grids apply if you've got physical issues, and if you're over 50, you always want to look at them, just regardless. And then the third theory is functional capacity, which is more of a kitchen sink argument, where basically you say the combined effect of all my problems, my back pain, my diabetes, my nausea, my restroom issues, prostate issues, or my, kidney issues, kidney stones, or my depression, my PTSD. You put them all together, no one of those things might be enough to get you on to win a disability case, but the combined effect, medication side effects, a lot of times, the combined effect of all these things, when you add them all together, it so reduces your capacity to work that you would simply not be reliable. That's the functional capacity argument. So when Jose says, do you find it easier to argue functional capacity over jobs in limited numbers? It's comparing apples to oranges, because when a judge asks a question, he or she will will present what is called a residual functional capacity. Residual means what's left over. The judge will present a functional capacity profile. We have a hypothetical person, that's what they do, who is cannot climb ladders, ropes, and scaffolds, cannot walk on uneven terrain, would need simple entry-level 1 or 2 step jobs, would need to be near a restroom within 3 minutes of a restroom at all times. That's an example of a functional capacity. It can get real detailed. And then the vocational witness would say, well, there are no jobs out there, or there are jobs, and here's some examples of the jobs. And what Jose is getting at is, if the VE says, well, this person could be a laundry marker, but the laundry marker job market is reduced by the person not being able to use their right dominant hand to write or use fine motor manipulation for more than 15 minutes in an hour. So that would reduce that job base. And so what he's getting at is, if you can argue to the vocational or to the judge that the jobs that the vocational witness has cited, that in a vacuum, there's a lot of these jobs, but when you start factoring in all these other factors, that starts eroding the job base. So you can attack the vocational witness testimony that way. The problem is that, first of all, judges, in my opinion, do not like when you go after vocational witnesses really hard. Some attorneys do that. There are several attorneys out there I know who have a very, very successful approach towards going after vocational witnesses, and they'll challenge the vocational witnesses' statistics in terms of job numbers. because the Dictionary of Occupational Titles, which is what many VEs use, is outdated. There's different resources now that you can argue that the number of jobs that the VE has cited are too small to really constitute substantial work. That is a difficult thing to do on the fly. It's probably a better argument, in my opinion, to do it on appeal. If you really know the jobs, and certain vocational witnesses typically cite the same jobs. If you study that and really know all those jobs and the real numbers behind them, you could make that argument to the VE. And again, some of my colleagues do that. My thought has always been that if you're having to find yourself arguing to the VE about the number of jobs, you're probably not doing well anyway. You're probably losing. So I would rather, argue their case that there's no jobs because there's so many limitations on my client's functional capacity that no jobs really exist. So the answer, Jose, to your question is I do argue functional capacity a lot. I'd say that's about 80% of the time when I argue in a hearing, other than the grid rules, maybe the grid rules about 25-30%, but I don't typically go into the limited number of jobs argument in a hearing because I think that takes a lot of time up. I don't think judges really like it, and that would be something maybe to raise an appeal. Christina, another regular, thank you. Please do not forget to like, share, comment, and subscribe to my YouTube channel. Thank you very much, and please leave me a review. Thank you, and I'll put this. I've got this on here where you can leave a review, which I would really appreciate. Thank you, Christina, for making that comment. I really appreciate that, and thank you for being here every week. Nice. Okay. Thank you very much. I appreciate it. Nice. Nice has a question. If someone is getting SSI and SSDI, and that will turn into retirement, can they stay on SSI besides getting retirement? I think the answer is probably no, because SSI is a means tested program. And I believe, and again, I don't want to say absolutely, but I'm pretty sure that I know that SSDI offsets SSI. So if you're getting, SSI is limited by statute. So you're never going to get more than, I think it's like right now it's like $1,000 a month, or something in that range. If your SSDI is $1,500, then every month you're getting SSDI, it offsets the SSI. I believe, but again, I'll see if I can double check this, that retirement Social Security also offsets SSI. So in that situation, if you're getting your retirement, you would not be able to get SSI because the offset you're making, you're receiving more in your retirement Social Security than you would get from SSI. Therefore, the SSI goes away. So usually you don't see that. I guess in some circumstances, the amount of your retirement and or SSDI is low enough where there's SSI could still apply because your SSI is higher than your retirement or SSDI. That's pretty rare, however. So I think that's not real likely you're going to see both. Generally speaking, you can't double dip. Let me just put it that way. All right, we have another question here from SA, who I believe is also, I've seen SA before here. SA says, I cannot afford a partial hospitalization program for severe depression, anxiety that was recommended. Will that cause me to lose? It won't cause you to lose, but I think that, in general, whether it's physical or mental health, ongoing treatment is really necessary, because Social Security judges generally think, my experience, that if you're not getting treatment, then there's nothing wrong with you, or there's not much wrong with you. That's really not the case, because a lot of times you're not getting treatment because you can't afford it. But that's the reality, is the way they approach it. I think in the case of mental health issues, depression, anxiety, PTSD, not getting treatment is a real problem, because you need to have a paper trail documenting what's going on. So if you can't afford the partial hospitalization program, I would say look to see if they have any low-income programs that maybe would allow you to do that, or maybe there's even a community health center where you can get ongoing treatment. You got to get some treatment. You can't, gaps in treatment record are not good, especially in the case of mental health. So it will make it more difficult to win, not impossible, but more difficult to win. And again, you can have, just to go back to that in a second, you can have significant mental health problems, and you can have, I will tell you what my standard would be. I look for inpatient hospitalizations I look for multiple failed medication trials. I look for ongoing treatment that's not really worked, suicide attempts, indicia of severity. And so, even going to an outpatient program, that's helpful. But to me, you've got to have a lot because, depression, anxiety, PTSD, you can't image them. You can't take an MRI of depression. So, judges are looking for, treatment or other things that show that yours is more than just, bothersome. It is work preclusive. And that's hard to do. And that's why the more treatment and the more more firm up you have, more the firmed up your treatment record is, and the more support you have, the better. Okay, Mikey says, a local office started a final review of your appeal on September 5th. For most people, this review takes 15 to 30 days. Is this a generic message? Yes. Does it suggest you pass? No. It's a generic final review of your appeal. What that means, I believe, is that the adjudicator has sent the file to the medical expert. The medical expert's made his recommendations or her recommendations. It's come back to the adjudicator. Now the adjudicator is having this looked at by a senior staff member to make sure it's correct. It doesn't mean you won, doesn't mean you lost. It just means that somebody else is looking at it. There's an internal procedure they have to review. Have to review records. Post-hearing, I think a lot of these messages are just boilerplates. I wouldn't pay a lot of attention to them. And because something's had a final review, it doesn't really mean much of anything. Okay. All right, Derek, the question about back pay and workers' comp settlements, I'm happy to answer that as best I can. I will tell you in general about workers' comp, it does not play well with Social Security disability because workers' comp offsets Social Security. So every month you're getting workers' comp, if you're getting that, what they call TTD or temporary total disability, which is usually weekly, and it's typically a percentage of your earned your earnings, many times more than your Social Security. But let's say you're getting $1,400 a month in workers' comp. Every month you're getting that. And then if you qualify for Social Security for those months, let's say that you're getting workers' comp, you win your disability, and it goes back to April of 2023. You were getting workers' comp in April, May, June of 23. It's going to offset. Though you won't get any Social Security for it. There will be no past due benefits. So until you settle your case, every month you're getting workers' comp, it reduces or usually totally offsets Social Security disability. And that's why, by the way, that I'm reluctant to take a case when somebody's getting ongoing workers' comp benefits. There's no past due benefits, no way for me to get paid. So can't really take those cases. Now, when you settle your case, I can't speak for every state, but many states that I've seen, your settlement can contain language that we call it Hartman language, Hartman. And what that does is it says, this $55,000 that you settled and that you receive after the attorney's fees, this represents, a reduction. We assume that your lifespan will be 78 years and 4 months based on this table. There's certain tables they use, and that's I don't know how many months, 300 months from now. And so we're going to treat that as if it was paid out over 300 months. So you divide $55,000 by 300 months. I'm just making those up. And it comes to some number that reduces your Social Security, not 100%, but it reduces it by $100 a month, $120 a month, $57 a month. That way, if you've got a settlement, you get your settlement money and you get your Social Security disability. It's not reduced 100% or totally. So that's what you look for. That's what I look for when there's workers' compensation. There's also in workers' comp, to make it even more complicated, something called a Medicare set-aside. And what that means is that Social Security, as you know, once you become eligible for Social Security, 24 months after first payment, I'm just reporting the facts, folks, it's ridiculous, but 24 months after first payment, you become eligible for Medicare. Medicare does not want to pick up the cost of paying for medical treatment related to a work injury. So many settlements over a certain amount have to set aside a part of that settlement. By the way, there's no attorney's fees on that, but set aside $30,000, $40,000, $50,000 that will be used for future medical care. And many times, in your stipulation, workers' comp, you've got to agree, I will not, as part of making Medicare agreeing to this, I will agree not to file for Social Security for, a year, 2 years after my settlement. Again, it gets really complicated, very granular. I'm just giving you kind of the bare outlines, but it's you can see how it gets really, really confusing. It's important to have a knowledgeable attorney in comp and someone knowledgeable in Social Security. I've had cases where my client, my wife, for example, and we have another attorney in the office who does workers' comp, and they'll refer me a case. Person's totally disabled. And I'll look at the paperwork and it will say no Social Security for, 18 months or something like that. I'll tell the client, look, we can't file for 18 months because otherwise you run the risk of having Medicare say we're not paying for anything. Um, and so we have to wait. Then we also have to be aware of the date last insured for disability. So, there's a lot of stuff going on, a lot of moving pieces, and it can get really, really confusing. I hope I didn't bore everybody with that, but my point is simply that if you have an ongoing workers' comp case, Social Security, don't just file it. You should really talk to an attorney because sometimes when you file it, it may be too soon. It may screw up your settlement. So just be real careful if there's workers' comp involved. Okay. When I request an ALJ hearing, ask Kay Wolf, do I prefer phone or video and why? Thanks for my advice, etc. Thank you very much for the kind words. I personally prefer phone. And the reason for that is that video is technically more complicated. And I've had more than a few video hearings where we can't hear the claimant, or there's background noise, or there's an echo, or they can't get on at all. There is something nice about seeing the judge, but I don't think you lose anything by doing a video hearing. I mean, an audio hearing, telephone hearing. Judges are not really allowed to do what they call sit and squirm jurisprudence, which means they can't look at you. Oh, you look disabled. Now, I have a case coming up soon where my client has a condition that is one where it might not be a bad idea for the judge to see her. I'm not going to go into what it is because it's obviously confidential, but she has a certain thing that happens that again and again and again that a judge might be better for the judge to see that. So there are some circumstances where I might recommend a video hearing. There's also every once in a while a situation where a live hearing makes sense. Some people really like live hearings. I don't think there's really a lot of utility to them. Some lawyers really like them. But again, if you have certain things that maybe would make a visual impact, it might be something to consider. Again, I think a video would probably do just as well, and judges are not supposed to look at you, but judges are human, and there may be certain circumstances where that would make sense. And I will tell you, I've had situations where somebody calls me from a different state, and I think that live might make more sense. And I'll say, look, I'd love to have your case. I think it's a winning case, but let's get you somebody local because I think you might want a live hearing. So, that's you just have to kind of judgment call. Doesn't happen often, but it does happen sometimes. What is the role of AI, artificial intelligence, in ALJ hearings used to summarize and analyze a case file and cover fact? At this point, Social Security, if they're using AI, it is on a test basis. I don't believe there's any evidence to me that they're using AI on an ongoing basis. Now, there are a number of AI vendors out there that offer their services to lawyers, and I've tried a couple of them where I will put and you've got to deal with confidentiality and HIPAA and so forth. So there's that whole part of it. Let's assume that's we're okay with that, and my client's okay with it. I will take the PDF of the exhibit file and I will upload it to the AI engine and basically say tell me what the main issues are here. I have not found it, as of about 2-3 months ago, is the last time I tried it. I've not found that it works. It gives me the confidence to use as opposed to the old fashioned of reading the file, taking notes on it, and preparing that way. That may change. And I know that I know people who feel that AI can do some amazing things. What I found when I tried it was, one thing was that AI was really biased towards the amount of evidence for a particular condition. I've given this example before, but my client in this particular case had foot surgery, had a number of procedures on her feet, and they were not major procedures. It was, some tendon issues. Yeah, it was uncomfortable, but it was not going to stop her from doing work on a sit-down basis. But there was a lot of it out there. So when I queried the AI engine, what's the most important thing here? The foot. Well, that wasn't going to win the case. She had back issues and she had other things that were much stronger. But the AI engine saw a lot of foot, procedures. So it told me that the feet was the problem, or feet were the problem. So, I don't think that, we're there yet. Is it possible that in 5 years there will be AI analysis of files, and that judges will use them, and that lawyers will use them, or maybe replace lawyers? It is possible. Let me tell you, in the legal listservs and the conventions, you hear a lot of talk about AI being out there that could replace lawyers or reduce the need for lawyers for certain things, and that is very possible. AI is Bill Gates, I think, said that AI was the most significant change that he's seen in his lifetime, and obviously he's seen some pretty significant things, more than the internet. It is not there yet, in my opinion, but it may get there. But I still think that even with as great as AI is, and the potential for it, there's nothing that's going to substitute a experienced attorney looking at something, or a judge looking at it and making a judgment call. I'm sure you've heard of situations where, well, I'll tell you, in the federal courts, now many judges require lawyers to certify that the briefs they submit, pleadings they submit, were not done by AI. Because what happened was there have been some instances where a lazy lawyer used AI to draft a brief, and the AI engine, used incorrect citations, and it was just factually incorrect. And they presented this to a court, and the judge was not real happy about it. So, we're a ways away, but you know what? It may be that over the next couple of years, we'll try to do more. I can see an AI application where, you put your facts in and ask the AI engine, do I have a winning case based on all these, all the information that's already in there, and it can tell you. But again, I can look at a case and say, with usually with pretty good accuracy, this is going to be a winning case, assuming we have a reasonable judge. But again, there are factors there that are beyond what the AI engine did. So yeah, I think it's not being used, to my knowledge, at this point, but it is, I think, coming in some way or shape or form. Yeah, well, and Derek makes a good point, is that Social Security's computer systems are, not at all modernized. That they have, and if you look up, and you can, I think there was some articles in the Washington Post by a lady named Lisa Ryan, Rein, and she talks about the computer systems that have been, they keep spending all this money on these computer systems, and they don't really work together very well. So I think, there's going to have to be a lot more updating, getting these computer systems up to speed before they can really use AI with it. And look, they're still using the Dictionary of Occupational Titles, which is last updated, in many cases 40 years ago. So, before we get to AI, let's get the DOT updated or something to that effect, something replacing it. Okay. Gerard, I asked SSA to suspend your application while you try to unsuccessfully to work. Can I restart? Well, first of all, Gerard, I would not recommend that would not have been my recommendation. Realize that, when you apply for benefits, as you probably correctly know, that when Social Security defines disability in terms of your capacity to perform substantial gainful activity. We always abbreviate it as entry-level work, but substantial gainful activity, which could be a simple job, it could be volunteer work, it could be going to school, something that is equivalent to a job. And once you apply, because your onset date could be as of some date that you chose, either on or before the date you applied, once you've got an onset date, you become eligible for what is called a trial work period. So if you apply, and let's say you apply in September of 2024 and allege you became disabled in July of 24, make it simple, and then you take a job in September and you work at that job for 3 or 4 months, well, you have 9 trial work period months. So if you later on, are found disabled, a judge could find those 3 or 4 months that you worked part of your trial work period. They could find them an unsuccessful work attempt. So there's no need to suspend an application. If you were successful in your job, then you really didn't need to worry about it. You basically just cancel the application. But if you're not successful, you wouldn't have to go back to restart it. But yes, the answer would be you can restart the application, but see if they'll restart this. If they did, I'm not aware of a way to suspend it, but if they did suspend it, then try to go ahead and get that redone. You may have to refile, and then ask them to reopen the old application. But I would not, once you are in process, let it take its course. And if you try to work, look at that as either an unsuccessful work attempt or trial work period. And if you're successful, cancel the application. Otherwise, you stick with what you got. Realize you can always go back. If let's say you're successful with a work attempt for a period of time, when you get your hearing or even in the administrative level, you can change the onset date. So you have a lot of options there, but suspending an application is, in my opinion, not a very good one. Woody, I called your office. Well, Woody, if you did, I hope you got to speak to I hope somebody in the office, one of my call screeners, Madeline. We got a couple other people. I was working on briefs and doing pre-hearing calls all day today, so I was not available for the most part because I have a bunch of hearings coming up. I was doing my pre-hearing work on those and talking to my clients and working on briefs. If you're to put your case, well, realize, okay, Mikey says you put your case file in ChatGPT and analyze it would be successful predicting a case. My answer would be this. First of all, I would be concerned about whether ChatGPT is in fact a secure, private, confidential place to put your information. I don't know that it is. So that's one concern. The second thing is you only get out of my understanding, and I've really only just looked at it a couple of times, you get out what you put in. So, if you prompt it appropriately, you'll get better responses. So I don't know the right prompt to ask ChatGPT whether your case will be successful. I guess you could say, based on, I've uploaded my file. And again, the prompts in artificial intelligence are really, I think, a real key thing here. And I don't know, I've played with it a little bit. I've actually played with a really interesting AI engine that does graphics. You can say, show me a picture of a, 45-year-old male who's struggling with bills or something like that. And it's really kind of interesting how that works. But as far as using it to predict an outcome of a case, I don't think we're anywhere close to there yet. So, nothing wrong with trying, but I wouldn't do it. I don't think I'd rely on it. Okay, Rodney, how are you doing, Rodney? Hope things are well. Tammy says, hi, Tammy. Mrs. B, can I fight for LTD and Social Security at the same time? Absolutely, and you should. I'm going to be I'm doing some work with a gentleman named Eric Berger, who's a long-term disability insurance lawyer, and we've done some videos together. LTD, most LTD policies, if they're company provided, they will require, not the ones you buy on your own, the ones you get through your company where they take it out of your paycheck. Most of those policies, almost all of them, require you to apply for Social Security disability. And if you get on Social Security disability, it really benefits the insurance company because the insurance company then reduces what they have to pay you. So if Social Security, let's say your LTD benefit is $2,000 a month, Social Security is $1,500 a month, then you win Social Security. Long-term now pays you $500. Social Security pays you $1,500. It also, you don't have to pay back the attorney's fees. In other words, you have to pay them back the lump sum you get because you were getting long-term disability at the same time you're eligible for Social Security. You don't have to pay back the attorney's fees, so they actually pay my fee. So I like long-term disability cases because it won't cost my client anything at all. But the question is obviously, if I'm not going to get any more money out of it, why do I need to bother? Well, A, because the policy requires you to do it. And secondly, and really the most important thing is it gives you backup. LTD insurance companies are notorious for trying to cut people off. So if they try to cut you off, then you get cut off or they suspend benefits and you've got Social Security in the background, you've got money coming in. You've also got Medicare, which could come in very handy if you lose your insurance. So any number of reasons why you want to do LTD, but I would do it at the same time. Some LTD companies will say, we've got a non-attorney rep firm that will help you with Social Security. I think you get what you pay for. I've taken over a lot of those cases. I've had people call me. They're not real happy with the rep firm. There's some that are pretty good, some that are not so good, but you typically get a different a case manager. I'm not a big fan of using that. And usually if you say I want an attorney, they will back off and waive fees. There's no problem for me to get involved in those cases. So I do, I'd say it's not an insignificant number of my, of cases, maybe 10%, let's say, there's a long-term disability element to it. And, I get involved in the Social Security part of it. We win. My client has to basically pay the lump sum check back to the long-term disability carrier because that's what the contract provides for, but there's no cost. They don't have to pay me anything. Long-term really picks it up because it benefits them. But yeah, I think you should apply for both at the same time. Well, thanks, Mrs. B. I'm glad you were here. I usually do this on a Wednesday night. As I've told everybody, my wife got tickets to Music Man, which is a really interesting, really fun musical. If you ever get a chance, it's a community theater here in Atlanta. And so we went, and we just had some friends that wanted to go on Wednesday night. And so that's when we got the tickets for. So I'm like, okay, I'll just make this Thursday night. I figured maybe there's some people that otherwise don't see me on Wednesday that maybe will pick it up on Thursday, and you were one of them. So I hope to see you again. Most of the time it's going to be on Wednesday, but I've got a couple of them coming up where I'm going to have to do it on Thursday or even Tuesday. So we'll see how that goes. But I give plenty of notice on the when I put the notice out there. Rodney asks, does Social Security spy on you? They have the right to do that. My experience has been, especially if you're over 50, and I think, Rodney, you are, it's pretty unlikely. The only time you're going to see it would be if there's somebody, there's evidence of fraud. And usually that's because, somebody writes them a letter or calls up and says, I think Rodney is committing fraud. I've seen him do all this stuff. So if you have a nosy neighbor, an angry ex-spouse, an angry, ex-coworker, you got to be more careful about it. But generally speaking, unless there's a reason to spy on you, it's not going to happen. Okay, garden dogs. Okay, they have an interview with the phone. Well, basically, when you file your application, you probably call them. They take a very little bit of information. The phone interview, they're going to go through the questionnaire or the intake form, the application. Let me get my terms straight. So if you just type in ssa.gov/apply for disability, you can see the questions they're going to ask you. And it's just to complete the application. You'll want to have your list of all your doctors. You want to have your list of all your medications, things like that. But it's just to complete your file. All right, Gerard says, does every application go before a judge or some decided administratively? Some are decided administratively. Again, if it's really, really serious, you could get approved at initial. You don't even need a lawyer. I've had people that, I've got, pancreatic cancer, God forbid. What I'm going to say to them is, go ahead and apply. You don't need me. Go ahead and apply and just reference this, compassionate allowance or TERI site. TERI stands for terminal illness, in this listing, and they should approve you. Call me if you get denied. And so it's pretty rare they're going to get denied. I have a number of other ones. Usually it's grid rule cases, people that are 58 years old with significant medical problems. In those circumstances, I may argue the grids in the application, or, pardon me, wow, long day today. Played a little tennis too. But the grid rules, you get them approved early. I've got a number of people that have been approved early. Sometimes that means there's no fee for me. Sometimes a very small fee, but that's fine. A win's a win. And I'll tell people, write me a nice review if we win early. So yeah, you can certainly get approved early. I would tell you, usually, not always, but usually it's going to be people who meet a listing, people who meet a grid rule, or somebody who's late 50s or early 60s with a lot of significant medical problems. Although I have a hearing coming up, I think Tuesday. I talked to my client today with a gentleman who has significant debilitating medical problems. I'm shocked beyond belief they didn't approve him early, but they didn't. So you just never know. Never know what you're going to get. Okay, Michelle, I have a hearing coming up soon. I have an attorney. What can I do to prepare for the hearing? Good question, Michelle. Well, first of all, obviously you want to talk to your attorney. I've got on my YouTube channel list of a playlist is what they call it, of preparing for your hearing videos. Take a look at that. I will tell you that certain questions always get asked at hearing. You want to know about your past work. Make a list of the last 5 years, all the jobs you've done, what you did, what your responsibilities were, how much you had to lift and carry, how much multitasking you did. Was there any supervisory role, things like that? Really kind of know what your jobs were. Have a list of your medications in front of you, knowing what your medications are, what the side effects are. Have a clear idea of what your medical issues are, using the correct terminology, and be able to speak about the practical problems that arise from each of your medical issues. So if you have a herniated disc, you don't win because you have a herniated disc. You win because you have radiating pain into your right leg that causes terrible sciatica, and the level of pain is such that you cannot focus or concentrate. The only thing that seems to help a little bit is Neurontin or gabapentin, but that puts you to sleep. So you want to have, be able to describe in very specific detail how your medical problems limit you from working. Remember nothing else, Social Security disability is about your capacity for work. So you want to really focus on those things that impact negatively your capacity to work. And again, those are the questions. And if I've got a video out there on my channel, expect these questions. I go through all the questions that you're likely to get at your hearing. And again, medications, past work, having kind of an elevator speech for each of your conditions. If the judge says to you, Michelle, why can't you work? You want to be able to answer in 3 or 4 or 5 sentences why you can't work. And you don't want to, and I'll tell you a couple of things not to do. Don't come in there with the idea, I know I'm disabled, nobody would hire me, or prove my case. You want to go in there and say, I hate the idea of being disabled. This is, it's caused financial stress. I've lost my self-worth. I don't have an identity anymore. I've lost my friends. I hate this. I would much rather be working. So you want to go with the attitude of, I'm a fighter, I'm not that you're entitled to anything at all. And I think judges really appreciate that. So those are just some thoughts. Bless me. I sneezed. Thank you. But you could say just bless me in general, which I'll take that too, but I think it's because I sneezed before. Appreciate it. Okay. Mr. CT, good evening. I turned my paperwork stating I'm not getting workers' comp payments, so they can start my full disability payments 6 months later. Still nothing. All right. What should you do? Well, again, if you settled your case, you're going to need a copy of that settlement document to show that you have that Hartman language. That may be the holdup. If that's not the case, if there's no settlement, you need to get a hold of somebody at Social Security to ask why. Call your local office. I mean, just start there. Ask, why are they not starting my benefits? What's the holdup? It's probably somebody needs to change the status in a computer system someplace. If you can't get anywhere with that, reach out to your U.S. representatives. I prefer senators, but you could use a U.S. representative. Ask them to go to bat for you. But that's what I would do. Okay. How long does an appeal take? Now, Jeff, are you talking about appeals from unfavorable hearing decisions? Are you talking about an appeal of a denial? I'll give you the overall time frame, my experience. You apply for benefits, you can expect to wait, in general, 8 to 12 months for a decision. Way too long, but that's what it is. If you get denied, you have 60 days to file an appeal called a request for reconsideration. It's going to take 7 to 12 months for the recon to be processed. You get denied at recon, you have a chance, you have 60 days to file a request for a hearing. You'll get a hearing date, 5 to 7 or 8 months. 5 to 7 or 8 months. It's not that long in the hearing because they have more capacity at the hearing level. If you lose at your hearing, you have 60 days to file an appeal to the Appeals Council. That's going to be 8 to 10 months. You lose the Appeals Council, you have the right to file an application with the district court for a district court review. That's going to take probably 8 to 12 months there. Some states are worse. Texas, Florida, a lot worse. Some states are not as bad. So it just depends on where you are. But that's kind of the general time frame. Does my husband's income count for income, the overall scheme of things? Only in an SSI, not an SSDI. SSI, they do what they call deeming, where they look at your spouse's income, other household income, and they reduce your SSI by that amount. They do not do that in SSDI, only in SSI. Um, Mrs. B. Oh, okay. Thank you. Okay, good. I probably sent you to Eric. It's probably, yeah, that's, yeah, again, I've done them before, but I don't like to dabble in it. So, I usually refer them out. And again, my buddy Eric is a good, very good resource for that. He's a real nice guy. And he was actually up here a few weeks ago. We spent some time together, did some videos together, and we're going to do more work together, I believe. I'm the best. Well, I appreciate that. I mean, there are some, I will just take it as, look, I'm happy to do what I do and hopefully I do it well. There are obviously a lot of people out there who are, probably a lot smarter than me, certainly a lot smarter than me that do things I can't do, but I try to share what I know. And that's what the goal here, share what I know. And, again, I've done it long enough where I think I know what I'm doing in this area. Got a call from a case analyst, which is like an adjudicator, being sent from mental health CE, mental health assessment, didn't apply for mental health, thoughts, 56 major spine issues, fusion. Okay. What's going on here is that the adjudicator, the case analyst, is made a decision to send you out for a psych CE. It could be a number of reasons for that. Number one, it could be something in the record that they've got that suggests that there's some depression or anxiety. That's one possibility. The second possibility is that they see the case analyst thinks you meet the grid rule, but they need to get rid of transferable skills. So they send you out for a psych CE, and it comes back to say that you have problems with focus and attention and concentration because of severe pain. Gets rid of the transferable skills, you get approved on the grids. That could be what's going on. Or it could simply be that the adjudicator just sends everybody out for psych CEs. But I would say it's probably more one of the two, that there was something in the record to suggest it, or they see this as a case where the grids could apply and they want to get you approved on the grid. Okay. Let's see. 21 months in, Kelly says, I'm in step 4 final review. SSI and SSDI is working. Well, SSI is probably denied because they saw earnings, household earnings, or assets that would disqualify you non-medically. If you've been waiting 21 months, that is way too long. I would say that's where you need to contact your elected representative. So, it's not a good or bad sign. It just means that they're way behind, way too far behind. And I would try to get a elected representative to kind of get things moving on your behalf. But that is, I'm curious if you're in Texas or Florida. That's just way too long. Rajul got denied 2 appeals and we're in a court hearing. I have to wait for a court hearing. Law firm didn't speak to a lawyer. Okay. So you've lost at the recon appeal and now you've got a hearing. Normally, like I said, it usually takes between 5 and 8 months to get a hearing. The hearing judges are not as backed up as the people at recon or initial. So I'm seeing hearings in 5, 6, 7 months. You will need to talk to your lawyer at some point because I think that, there's a lot of stuff that support staff can do, a good paralegal can do, but your lawyer is the one who's going to present the case and you need to talk to your lawyer. I would continue to ask for a meeting because I think that, that's only appropriate. Vince, how are you doing, Vince? I hope things are going well with you. Thank you for dropping by. Okay, Mrs. B asked, could I apply at the same time as Harvard? Maybe apply for Social Security. I have to fill out these paperwork. It's going to be function working. Yeah, so, that's the one thing when you apply for disability and long-term disability, you're going to have all these forms to fill out. It can be overwhelming at times. But I still think there's no reason Social Security takes so long. Why wait? It's just something you're going to have to do. One of the things I provide, by the way, for my clients is I've done screen capture videos of many of the forms that you see for Social Security. So I give them access to that library. I'll tell my clients, do the form as best you can, send it in to me, let me review it. I will not actually complete the forms. I don't think, because I think it's evidence. I just don't think it's appropriate for me as the lawyer to write down where my client's pain is. That needs to be coming from my client. I'll help, I'll give you guidance, but I will not actually fill the forms out because I just think that's inappropriate. Because if, I just imagine you're in a hearing and the judge says, well, you said in this form that you have pain in your left shoulder. Well, I didn't fill that form, but my lawyer did. Well, that just doesn't look good. So that's my reason for that. Okay. Charles Flynn. I have physical issues that prevent you from physical work, looking at the grid rules at over 50. How much does one education come into play? I have a JD, but haven't practiced in almost 20 years. I don't think it plays that big of a part, quite honestly. If you look at the grids, it talks about a high school education or more. And again, the question many times is, will your education, your skills make for a direct entry into skilled work? Well, if you have a JD, a law degree from 20 years ago, but haven't practiced in 20 years, are you really capable? Are you probably not even licensed anymore? You're probably inactive as far as your legal status as a lawyer. And things have changed so much that I don't think that's going to really make all that much of a difference. In fact, for past relevant work, they only look at 5 years. They changed that in June. The reason for that is because they realize, Social Security realizes that work you did 15 years ago is really not relevant to what you can do now. Charles was a lawyer 20 years ago, but what is that going to help him? He hasn't kept up with the case law, kept up with any of the the changes. They won't even consider that as far. So if Charles had a JD and he works as a lawyer last worked 20 years ago, and the last 15 or 20 years he worked at a retail shoe store, fitting shoes, the only past relevant work would be shoes, and the education really won't make much of a difference because it's so long ago. So, it can be a factor if you have a specialized education, but like I said, generally speaking, I'm able to get rid of transferable skills by virtue of the non-exertional impairment, like headaches, like pain, like fatigue, like bathroom issues, things like that. Big One is here. Hello, Big One. Big One is a little bit late. Well, okay. It's okay, you're here. Better late than never, Big One. Jeff Jackson gives me a emoji. Hello, Jeff. Where do we go to leave a review? Okay, well, I'm glad you asked that. I'll show you right here. You can do this here. Go to bit.ly/Jonathan-review-5, and you can do it there. Or you can just type in Ginsberg Law Offices in Google, and it'll come up, and you can go to the the reviews and add a review there. That's another way to do it, but that's how you do it. So I appreciate it very much. People leave reviews because it really helps me grow my practice. Rex, how are you doing, Rex? Hope you're doing well. Tis Matrix, TYS Matrix, or Ties Matrix, maybe. Ties Matrix. Hi, Ty. I hope that's what you mean. Should I be proactive and return all these forms before they request them? Physical, residual, functional. I think so. I would. I mean, there's no reason not to. It won't hurt you if they send them to you again. Just send them a copy of what you already sent in. But the more you can give them, I think, those forms, because that really translates your medical issues into work limitations. Absolutely. Why not? Why not? So I think it's fine to do that. What happens after a step 3 medical review? Are you talking about at the initial stage where it's in the DDS, the state agency, they're doing a medical review? Or are you talking about the 5-step sequential evaluation process? I don't know. I'm assuming you mean the case is being reviewed medically. And I'll get an adjudicator on one of these days, but I think, again, as I understand it, what happens, having had other adjudicators work for me over the years, is the adjudicator or case analyst gathers all the medical records, puts a file together, electronic file together. They review it, then they send it to an in-house medical expert in Social Security, electronically. They don't actually physically bring them a file. They send it to them electronically. The medical expert looks at the file and draws conclusions. This person meets a listing, they don't meet a listing. They meet a grid rule, they don't meet a grid rule. It's not the most thorough review, but it is a review. And then it comes back to the adjudicator with comments. And the adjudicator, if the adjudicator wants, or case analyst wants to fight for you, they may send it out someplace else, to another medical review person. They may send you out for a consultant, like we talked about in the previous question. Some adjudicators will fight for you. They will, and that's great if you can get one of those. A lot of times they're so busy, they just process it. It goes to review, goes back to them. They have their supervisor look at it, and they issue a denial notice. I think that when you are overworked, and I'm not blaming adjudicators for this, but if you're overworked and you've got a million things to do and you don't feel appreciated, it's really easy just to sort of say, this case is not a listing level case, not a grid case, deny it, move on. And I think that happens sometimes too. Okay, you can get a case evaluation. That is there. Big one. Okay, big one tells us that SSI is $943 a month. Let me just double check that. That sounds right. SSI in 2024 is $943, $943 a month. That's the big one is absolutely correct. Thank you for putting that in there. The other case evaluation thing here. Okay. Now I've got it. You see on this, if you want a case evaluation, you can get one. You would go to bit.ly/contact Jonathan with a capital C, capital J 3. That lets me know where you were coming from. So I appreciate that. Okay, Raymond the Brick Nut. My question this week is, are there statistics on remanded unfavorable decisions that are approved after a second hearing? Waiting to hear what my... if there are, I have not seen them. Social Security puts out a lot of statistics, and I usually look at, NOSCR, the National Organization of Social Security Claimants Representatives, will sometimes pull out an interesting statistical, sheet and distribute it to the membership. I know there's a couple of blogs out there. Charles Martin's an attorney, but now you got me thinking here. Social Security Disability blog. Charles Hall, that's his name. Charles Hall has a blog, very, very useful blog, and he'll pull out some of these statistics. But this particular one, I've not seen any statistics on. Okay, so Raymond had a hearing, second hearing, apparently got it remanded, a second hearing, and waiting for decision, and very, I'm sure, very, very anxious about it, which, I can understand. And I think we've talked about this in previous weeks, is are judges more likely to approve a case if it's been remanded or been sent back to them? And my answer is some judges yes, some judges no. It depends. Some judges feel like I'm not going to let the appeals council or the district court tell me what to do. Others feel like I don't want to get appealed again. All right, my buddy Garrett says hello. Garrett posts things here in the comments sometimes. We work together. Cheryl says, when does SSDI change to full retirement? I believe it's at full retirement age, 65 or 66 is when it changes. Raymond says, during his hearing, the ALJ said to David, must be your attorney, David, must be your attorney, that your earnings from 22 are not above SGA with other things that lead me to believe we won. The biggest issue is VE testimony from the first hearing. So yeah, it's helpful to have earnings in the past that are not SGA, because that gives the judge the leeway to approve you before that date. If you had earnings over SGA, then you got to get a judge who's willing to apply the trial work period, or otherwise change the onset date. Main event. Good evening, Maine. Hope you're doing well. And so Raymond's talking about the VE testimony from the first hearing, and he acknowledged someone like me with SA, talk about other stuff that never falls, sleep apnea. Boy, I'm yawning. I may have it here. On top of other stuff that falls asleep, but I have a hard time keeping a job. Let me just say this, and again, it sounds positive in general for what you're telling me, Raymond. Let me just say this about questions from the VE. Almost every case, the judge will ask multiple questions of the VE, and some of those questions will get an answer of, there are jobs here. They could do past work, they could do other jobs. Other times, the VE will testify in other questions. If there's a lot of heavy-duty restrictions, there are no jobs. It's not unusual to have 5 questions, 6 questions to a VE. One of those questions reflects what the judge is thinking. But people, sometimes will email me and say, well, the VE said that there's no work I could do, and I won, right? But then they get their decision, they get denied, and they send me the unfavorable decision. And I've had a couple of those where I'll take on the case to do the appeal, and I'll get the audio, and I listen to the audio, and sure enough, there were 3 or 4 questions that the judge, got the answer. There was no jobs. So you want to listen real closly to the questions to the VE, and some of them will generate the response of jobs, some will say no jobs, but don't recency bias can creep in. Don't, just because the last question asked was no jobs and the last question will be, Mr. Vocational Witness, assume a person, a hypothetical person, would be off task for 15% of the day or more, or would miss 2 or more days of work per month. Every VE is going to say no jobs to that. That's the last question you got. You won, right? No. That's a question the judge just asked to kind of, firm up the, his decision and to say he's considered everything. But maybe question 3, where the VE came up with 3 jobs at the, light, unskilled exertional level and skill level, that's the one the judge is going to use. So listen closely to it. Look, I would tell you, if you have an attorney, after your hearing, ask your attorney to download the audio for it and then get it converted to MP3. And I know Rodney, poor Rodney, he sent me his audio several weeks ago, and I've not had a chance. It's sitting right here. I'm looking at it. I've not had a chance to convert it to MP3 for him. But you can get the audio and listen to it, and listen to it carefully. And sometimes you'll be surprised as to what happened. You won't remember things. You'll be surprised. So I would definitely do that. Connie Ponton. My reconsideration is still medical review since December 23. I'll be 64 years, applied in September. All right. Should I start taking my Social Security retirement? If you need the money, take it. I think, number one, realize that if you take the early retirement and you ultimately win disability, you'll get bumped up to full retirement, and they'll make up the difference in the lump sum. So let's say you take it in November of 24, and your onset date was July of 23. You'll get disability from July of 23 to November of 24. Then starting November of 24, you'll get the difference between the early retirement and the full retirement. The catch is, if you lose disability, you're stuck at the lower figure. So if you have a strong case, and most people in their 60s, it's going to be a pretty strong case generally. It could be nothing significant there, but assuming that there's a reasonable chance of your winning, it's not a huge risk. But if if it's a matter of, you can hang on and see, look, reconsideration is not a high level of approval, but you could get approved there. That eliminates that uncertainty. If you're denied at recon, you file for a hearing, you got to make a decision. Do I go ahead and take the early retirement and risk being grandfathered in at this lower rate, or do I roll the dice, take the money that I need now, and then if I win, I'm going to get bumped up? That's just a question you and your lawyer would need to really talk about. But that's what you can do that. So I hate to say better off, because you just depends on your circumstances. If you think that you may not win, and you want to wait, if you can wait as long as you can, that way your retirement's going to be a higher number. Freedom. If I'm on SSDI and turn 62, can you change to regular SS and do a little work? I think the numbers will tell you, but here's my concern with that, is if you take early retirement, your number is going to be lower. I don't know that I would do that for that reason. You're going to be taking the discounted figure. And if you're getting early retirement, I don't do retirement Social Security, but if I'm not mistaken, when you start working after a certain point, every dollar you get causes your retirement Social Security to be reduced. You want to really look at that very carefully. On the alternatives, you could stay on SSDI and do a trial work period, or do below SGA. And as long as you stay below $1,550 a month in 2024, it'll be more in 25, then you can work. You can use 9 months of trial work period. Then as long as you stay under SGA, not a problem. So that may be a better option. I think I would just look at the numbers, how much you're planning on working. But I'm a little uncomfortable telling somebody to change their Social Security disability to early retirement. Doesn't seem to make a lot of sense to me. Tammy says she's watched me for a long time. You're currently my second time through the Social Security approval system, one other ALJ, and this time too. It is it's a challenge, isn't it? I mean, they really make it hard. They make it really, really hard. And I think, by watching like this live stream videos, other lawyers' videos, you educate yourself to get more ready. But at the end of the day, the underlying question is, do you have a medical condition that's logically going to generate symptoms that would prevent you from being a reliable worker? Faith says, UT took over 2 months to finally get someone to flag an application for compassionate allowance. I'm not sure what UT is. I'm assisting someone else. Now they have 2 conditions for compassionate allowance. Should DDS be notified? Yeah, absolutely. I think that if you are assisting somebody and they've got a compassionate allowance, scream it to the heavens. Tell everybody that can help you. Let DDS know. Let the adjudicator know. Let the supervisor know. Let them know. Put it in writing in bold type. This person meets it. Here's why. You don't want to be shy about that at all. Okay, what's your thoughts on using teleconferencing in combination with regular doctor visits to extract medical records related to work? A lot of doctors are using telemedicine. It's perfectly legitimate. If your doctor, you're comfortable with that, then it's certainly a lot easier to make appointments. I suspect it's cheaper. So, the more doctor visits, generally speaking, the better, because ongoing treatment is kind of the lifeblood of Social Security. They really like that. So, yeah, if you can get your doctor to talk about functional limitations based on, virtual appointments, go for it. Now, the issue you run into is that some appointments, they'll need to take blood. The doctor may need to see you. So perhaps you could use the virtual appointments to supplement your in-person appointments. Excuse me. Jerry Connor. I won my case. You're right. You can win on reconsideration, get your records, and keep them good. So Jerry won is an example of somebody who won at recon. It happens all the time. Good for you, Jerry. I'm very happy for you. Eric says, got pain meds renewed and 10 trigger points the other day at pain management, looking forward to our victory. Thanks for everything. Okay. Well, having pain medication is evidence of a significant problem. If you're on, especially an opioid pain medication, trigger point injections, you're having, an aggressive pain management protocol. That's very helpful. If your pain management doctor would complete a functional capacity form, that would be very, very helpful. That will help your case as well. And I think, as you know, I've got some of these forms. They're free ones here. I'll put them in the comments. If you need to get a functional capacity form, there's one. And here's the other one. A couple of people who do these for free. And it's really kind of cool that they do this. Okay. Let's see what we got here. All right. Daryl says, thank you, Donald Pig. Oh, I see your little emoji. Blessing to many people. My pleasure. My pleasure. Hello, Jen. Jen is our paralegal in beautiful Lincoln, Nebraska. Interesting how things work in now that law firms are virtual. I mean, Jen and I talk almost daily. We video conference frequently. We've never met each other in person. It's the way things are, So Iris is in Guatemala. She's another paralegal, a medical doctor in Guatemala. Never met her in person, but we talk on the phone and we chat and we video conference. So everything's kind of changed. But Jen does a great job in Lincoln, Nebraska. Mocan with Shrek as your, as your emoji. I don't know what that would be. Howdy, Jonathan. What's your SSDI for military PTSD, 7% nighttime nightmare diagnosis? Well, first of all, keep fighting to get that to 100%. VA ratings are not dispositive to Social Security. They don't, because you're found disabled by the VA doesn't mean you're going to win Social Security. I think PTSD cases in general are hard because it's invisible. You experience it. You talk to your doctor about it. I would say a couple of things I do in PTSD cases. Number one is I have my clients keep a diary of symptoms so they can talk about, many times in the military PTSD, it is going to be hypervigilance, being really bothered by loud noises, car backfires, planes flying overhead, firecrackers, things like that. Really know your triggers. I think again, you want to make sure you keep a diary of symptoms so that you can go back and say, I've kept this diary for the last 8 months, and 5 or 6 times a week, even at home, even not doing anything, I was triggered. How long were you out of out of sorts so that you couldn't focus and concentrate? I think that would be very helpful. If you've got other people, former coworkers or even friends that have observed you're having a kind of a meltdown or a crisis, have them fill out a form, a 795, SSA 795, where they can talk about what they observed. Just write a letter to them, they concern. They can talk about what happened to Mo. And when he was in having a crisis. Microphone cord. He was actually. I need to see if I can get a cord. I've got a cordless mic. I haven't tried it with this. I need to do that because I got a big. Get this long wire here. It's a good microphone, but it's a long wire. So, but yeah, I think that would be helpful. I think that if you're taking medications, it's a little closer here. If you're taking medications, are there side effects to those medications? What are the side effects? How has this affected your relationship with, family, friends, things like that? But I think really PTSD, the other thing that I noticed with PTSD cases, judges tend to be more receptive to them when it was personal to you. You were right next to somebody who got blown up, God forbid, or you were, a bomb hit and you were thrown against a wall and you got a closed head injury too. Something like that. I have a client now who was in a house fire and got PTSD from that, but it was personal to her. Seeing somebody else, 50 yards away get shot, it can be traumatic, but that's a harder sell to a judge, I think. So I think that would be, but I think just the more you can document it, the more you can take something that is inherently subjective and make it objective. I think that would be really, really helpful. And again, statements from other people, pain diaries, I think medication diaries, things like that can really, really help. You are very welcome. All right, cancer-free, how are you doing? I am married. I've filed for SSD and SSI, but I've been with them for 10 years. Is it going to affect anything in your case? I don't know why being married for 10 years, you're talking about using his earnings record? I don't know that you can if you have your own, if he's still alive and you're not divorced. So I'm not sure if I quite understand your question. Now, if you file for SSI and your husband works, that could be a problem for deeming rule purposes, but not for SSDI. But I'm not sure what you're getting at. Maybe I'm missing something. I apologize. Derek is back. I did the telephone hearing because I look healthy, but hang out with me for 3 hours, you'll see me dragging. Okay. And again, you make a very good point, and that is that judges are not really supposed to look at you and decide if you are disabled, but some do. So if you are really healthy looking, you're probably better off with a telephone hearing as opposed to an in-person or video one. Plus, again, the main thing, in my opinion, would be the technical issues there. At what age will full retirement? It'll turn into retirement Social Security 65 or 66. Willow says, I'm assisting someone who has compassion allowance condition. Took over 2 months to reach the right person to flag it. Now has two compassion allowance conditions. Should DD? I think we talked about this before. Yes. Cardiac. Yes. I would reference the particular compassion allowance by number and make sure that is submitted to DDS 3 or 4 different ways: fax, phone, letter. Just keep pounding them. This is compassion allowance. This case needs to be expedited. Keep asking and send it to the supervisor too. Don't be shy. Why do you have to apply for DAC or disabled adult child benefits when disabled before age 22? And how does it get you affect your approved SSI? All right. I don't do a lot of disabled adult child cases. They're hard cases to win because basically what you have to show is that you were disabled before, I think it's age 22. I think that's right. And let's say you are now 35 and you're trying to say, well, I'm a disabled adult child, because in order to pursue disabled adult child benefits, you have to have a parent or grandparent, your person took care of you on Social Security, either retirement or disability. So let's say that your dad, was working, and your dad now is 66 and just retired, and you're now 33. And you're saying, I want to be a disabled adult child. You got to prove that you were disabled going back now, 15 years. That is hard to do. That's the problem. It's so hard to go back that long. If you're on SSI, you're already found disabled, although realize that the SSI rules, certainly the listings, are slightly different than the adult rules. So winning SSI as a child doesn't guarantee you're going to be found disabled as an adult. It's I think a pretty strong factor, but it does not mean you're absolutely going to have that. So if you're an SSI and you age out of SSI, and you're going to disabled adult child, you're now in the adult disabled world. You can't go to SSDI because you haven't worked, right? So the only way you can stay on benefits is either stay on SSI or go to disabled adult child. And if you go on disabled adult child, the money's going to be better. And SSI, you might be offset because of, family support, things like that. So it would offset your approved SSI. So if you get disabled adult child benefit, it'll, offset it, assuming it's higher, the number is higher, it'll offset your SSI and cancel it out. Okay, Rebecca Renee. I've known several Rebecca Renees. That's an interesting that Rebecca people find Rebecca Rachel, Rebecca Renee. That's interesting as a middle name. Nice name, but I've noticed that a couple of times. Okay, approved 9/5/24, just a few days ago for SSDI. Approved the initial stage after the ALJ denial in February of 24. The report said disabled 12/22, but hearing decisions are binding. Right. So if you get and this is a really important point. If you are denied by the ALJ, and the denial date is February 15th of 2024, and you do not appeal, you file a new application, you don't appeal, the earliest onset date you can use is the day after your unfavorable decision. They will not consider in a new application anything that happened before the ALJ denial. They consider that a thing decided. There's a term for that. In the law, it's called res judicata. I'm not sure if they actually use that in Social Security, but that's what it is. Res judicata. It is a thing decided. Res is thing, judicata, decision, judicial decision. So that is the problem, is that you were found, Rebecca, disabled in December of 22, but because you already had an unfavorable decision and you didn't appeal it, you are now stuck with the day after your unfavorable decision. So the good news is you got approved. The bad news is you didn't get all your past due benefits. I always tell people, if you get an unfavorable decision, let somebody look at it for possible appeal. And if you're going to refile, normally I tell people, wait, if you refile right away, unless something really significant has changed, you're now 55 instead of 54, you have a new condition, you're going to get the same result. So I think that, it's pretty rare that somebody reapplied right away and got approved right away. Again, unless your age category changed. You look pretty young in this, but maybe you went from 49 to 50 and the grids applied. Or maybe the previous denial was based on your capacity to do past work, and now that was a 15-year look back, now it's a 5-year look back. So things can change, but I'm glad you got approved. Jeff says, how long, okay, I think we talked about this. I kind of gave you a overall take on how long things take. All right, cancer-free. My county, SSMI, well, it's the state agency. Okay, they sent you a statement, a letter saying they're doing work history. I'm going to go back to 2014. That's when I had breast cancer and called them and told them I had breast cancer. Was married. Nothing. Okay, married, not homeless. Okay, only thing I'm thinking here is maybe you were arguing that your onset date was 2014, 2015, in which case that work history could be relevant. But that's the only thing I can really think of why they would ask you for that. But otherwise, because now it's a 5-year look back. But unless you're arguing your onset date was way back at the time you had breast cancer in 2014, but of course you are now cancer-free, which is great. Um, can you be like a Lyft or a Uber, I'm guessing, rideshare driver with Parkinson's and still receive, let's say, if you earn the amount per month, very part-time life? Yeah, as long as you are under SGA, you can do that. That is not considered work. And again, as a trial work period, if you stay under that, then you don't use those up. $1,100, $1,110 in 24, and SGA is $1,550 in 24. So yeah, if you're a rideshare driver and you're under SGA, you can go for it. Now, some question whether that will trigger a review. It could. I mean, I think if you're consistently earning, $1,300 or $1,400 a month, maybe at some point it could. But Parkinson's is also a condition that doesn't really, get better spontaneously. So you're probably coded as a case of somebody not getting better. So I think if you can work, I would definitely work. Getting harder to drive, still to do it, but to drive for work, direct conflict. Well, I mean, there are jobs in the DOT and other sources that driving is a necessary part of them. So, being a courier, being a delivery driver, things like that. So yeah, it's a skill, it's a capacity that opens up the door, that opens up the possibility of more jobs. So yes, it is somewhat in conflict with saying you cannot work at all. But again, if you're only able to drive, for 15, 20 minutes at a time, and you take a 20 or 30-minute break, it's not vocationally relevant driving. It's got to be vocationally relevant driving. So driving for Uber, or Lyft or whatever, and you do that, and you're only doing it, maybe 2 hours a day with a lot of breaks in between, I don't think that's a problem. Don't think so. That's a problem at all. Yes, Eric. Okay, good. I'm glad you got a chance to talk to Eric. Nice guy, very, very sharp guy. And like I said, we're doing some work together. If you call him, if you do reach out to Eric, please let him know that I gave you his name. Okay. Glenn is in. How are you doing, Glenn? Okay. Eric, this is an interesting quandary here. This happens, it's, again, another ridiculous thing about Social Security. Eric is a few months away from his hearing. How can he determine what his monthly benefit would be? Because you can't get your My Social Security statement anymore. Why on earth they decided that once you file for benefits, you're no longer able to get your My Social Security statement, I have no idea. To get a My Social Security statement, normally you go to ssa.gov/my account, get your statement, see what your benefits are going to be. Once you're in process of a disability case, you can't do that. Now, your attorney can look sometimes, not every file, but there are files sometimes when you're looking at work history, that section of the file, I think it's section B maybe, it'll tell you what the benefit would be. So sometimes I'll see it. But obviously the better course of action would be to get your My Social Security statement before you start. But, and I've never tried this, but you could theoretically call and ask them. But, for some reason they decide to not give you access to that after you file. All right, JMR. Turned 42. Haven't worked since February 21. Developed POTS. Employer got sued. I'm not sure the OSHA issue is really relevant to your disability case. 42 is young, although I have won POTS cases for people in their 20s. The pot 40 is just, anybody who wins that would be on disability for the next 25 years, you're going to have a hard time. So anybody at 42 is going to have a hard time. I think there are judges out there who just, assume that anybody under age 50, they're going to deny unless you prove otherwise. If you have severe POTS where you literally cannot, get out of, hard to get out of bed, you have, you're falling, you're just, you're losing your blood pressure. POTS is a syndrome where when you stand up, you cannot, the blood drains from your head and you basically pass out. So it can be very, very debilitating, but it is also, again, somewhat subjective in that a doctor would have to accept your reporting of it, as would Social Security. So I think, and the back issue would certainly add to things there, assuming no workers' complication. But the back issue, excuse me again, the back issue would also be create limitations. So between the POTS and the back issue, you've got to identify specific limitations that would prevent you from working. Trish Wade, hello from Tennessee. Where are you in Tennessee, Trish? Hope that you are having a nice day. Okay. So basically, JMR is saying the POTS got worse. And I think if you can document that the POTS is really, really impacting you negatively, that's a good argument. Good argument. And at 42, it's still going to be tough. Glenna's on SSI submitted a first-party special needs trust. How long does it take SS? Honestly, Glenn, I don't deal with that enough to comment on it. I don't want to mislead you. A special needs trust would be, I believe, used to shelter or protect other income you may have from family or whatever, so that it will not affect your SSI. But beyond that, I would rely on the attorney doing the special needs work. I just don't know enough about it. Okay, I think we talked about this. At full retirement is when it changes. Mark, listened to Director O'Malley yesterday. Seems reasonable. Like he's a former mayor and governor. Yeah, he. I think I told y'all he spoke at the NOSCR convention in Nashville back in May, and he was very realistic. First of all, the fact that he showed up was really appreciated. No, I don't think a commissioner's ever shown up to an Oscar convention. So it was as a show of respect to attorneys. He basically said to us, look, we have a big personnel problem. We rely on you attorneys to prepare these cases, to make the arguments for your clients, and we respect what you're doing. Like, we've never heard that from Social Security. So that was really a welcome, to hear that, and really very much appreciated. People were very, very grateful to hear that. And he is apparently, from what I understand, he has regular meetings with the president of the NOSCR organization, and he's uses NOSCR's resources to get things, to learn about things that can be done. What are problems? We get these surveys. What are problems you're facing? We report that back, and it gets to the commissioner. So he's very open-minded about that, which is really appreciated. He suspended continuing disability reviews for a number of months to kind of work on the backlog. He's very transparent about the problem with the backlog, and he is very active on social media. And look, he's one person. He's trying to change things, but it's, as he put it, it's like moving a aircraft carrier. Very, very slow moving system. It's hard to make changes, to get things through. Some of it Congress has to allocate. Other things, he's got to fight the bureaucracy. But he is a good man. He is doing good work. And I, for one, really appreciate having a commissioner who I think cares about the disability applicants, cares about the lawyers, and wants to do a good job. So I'm very impressed with him. Okay. So this is the JM is the person with the POTS, and again, what the CE doctor tells you, don't take that to the bank, because you just never know what they're going to tell you. That they may say one thing, write something else. I was looking at a case today, my hearing for next week, and my client told me, because I was at the CE appointment, and my client happens to have some significant musculoskeletal issues, really bad back. And he said, I was on the table, and I kind of scooted up to the table because I couldn't put my socks and shoes on, and the doctor helped me do that. I couldn't get off the table. She had to help me get off the table. My client's a big guy. I look at the report. Claimant had no difficulty getting off the table. Claimant had no difficulty. I mean, it was like, he goes, I don't know what she's talking about. She had to physically help me put my socks on. So stuff that shows up in what the CE doctor tells you and what really is in the report may be two different things, which is why you want to look at those reports and see and make a note as to, this is wrong. So, I don't know that the fact that the CE examiner told you that your depression was a winning argument. Maybe yes, but maybe it didn't go in the report. You just see what the report is. Um, Here's the medical records. What are your chances of reconsideration in Georgia? Well, I will tell you in general that first of all, being 42 makes it really, really hard. That's I think it's probably not in your favor in that regard. Secondly, statistically, reconsideration is about a 18 to 20%. It's the lowest level of approval. So initial is like 33%, recon 15, 18%, hearings like 49%. You've also got something that is not imageable. So I think it's probably unlikely. Just to tell you the truth, I think it's unlikely. This is a case that will likely go in front of the judge, in my opinion. Yes, Sarah, you're 55. How long to switch to regular Social Security? Yeah, when you full retirement age at 65. Okay, Garrett's an organization person, so he recognizes what O'Malley is doing. And look, if you look at the SSA website, he's on videos all the time. There was somebody who's kind of made a snide comment. They called him Commissioner TikTok, which I think is pretty nasty, given that he's trying to tell people what's going on. He's out there. Look, he's a politician, and he was a governor of Maryland. He was a mayor of Baltimore, I think. Will he run for higher office? Probably. He ran for president at one point. He may do it again. And if he does, I think you should give him your consideration, because he's really showing that he's willing to take on a really, really hard job and try to do well. And I think he's a sincere guy. But yeah, he's about letting people know what he's doing, because he's a politician, which I can't blame him for. So, John says, I'm finally going to be getting Medicare in December. Nothing from the glorious state of Texas yet. If I do get additional help from the state, will there be reduction benefits from the feds? I don't believe so. I don't think that Texas has something like California's SDI. So you're talking about medical insurance, or are you talking about something else? I don't know, but I don't know there's any reduction in Texas. Okay, I think Jeff, we've talked about that before. All right, Terry, if your case gets remanded from the appeals council, some judges see that as okay, judge, you screwed up, grant this case. Other judges are like, I don't give a flip of what the appeals council does. I'm going to do it my way. It just depends on the judge. Some judges, are very much, I don't like getting remanded. It makes me look bad. There was an error the way I did it, and they'll be more likely to want to approve, but it just depends on the judge. Okay, so here is, actually, Garrett, you can go to Ginsberg, go to youtube.com, Ginsberg SSD, or maybe at Ginsberg. I'll have to find it, but I know if you go to youtube.com/Ginsberg SSD, that'll take you to my YouTube channel. You don't need to put in all this other stuff in here, because that's hard to read. But just type in Jonathan Ginsberg Social Security Disability or Ginsberg SSD, and you'll find it. Jessica. Okay. Thank you, Jessica. I'm assuming that's not your real name, but there's an S in there someplace. Christina runs Garrett's fan club, so she told me want to say hello. Jessica says, do not give up. It's quite the journey. Get a lawyer. Okay. I agree with that. Mr. CT, appreciate you. First of all, don't call me Mr. Ginsberg. It's Jonathan. I'm not real formal. And when you call me Mr. Ginsberg, it makes me feel really old. So I would appreciate just straight up Jonathan is fine. But I thank you for your appreciation. I do really appreciate. Look, I mean, one of the nice things about doing this live stream is I get to interact with all you fine folks, and it's kind of nice just to sort of, talk back and forth, and you don't get that sometimes by email. You lose tone and so forth, and this is kind of a nice format. Nelson, my case has been a recon since December 31. Well, I would tell you, you're now at 9 months plus. I think you should be getting a decision pretty quickly. And I would tell you, once you're at 9 months, if you don't get a decision this month by the 1st of October, I would reach out to your U.S. senator or representative ask them to do what they call congressional inquiry to get things moving. Deb is here. Deb is very knowledgeable about this. Always has good things to say. Full retirement for most people is 67, born in 60 or after is 67, born before that is 66, and some months are 65. Deb is correct. Thank you, Deb, for your comments there. I appreciate that. Dee, I called the call center for SS, and they got the doctor's report from IC and sent it back last week. It's been less than 10 days. Maybe I'll hear something soon. Maybe. Again, the adjudicator has to read it, has to send it to their doctor. I would tell you that things in the Social Security world typically move in months. They don't move in days, even weeks. Things take a long, long time. It's just unfortunate, but that's the case. Mrs. B, you are welcome. Thank you very much. Thank you very much. Dee, thank you. I had an attorney before I started watching. Okay, that's cool. There are a lot of good attorneys out there, but I'm glad you were watching. Look, there's nothing wrong with learning from whoever you can learn from. I learned from, I subscribe to Charles Hall's blog. I learned from that. I look at, I'll sometimes look at Walter Knott's live streams, learn from that. I'll look at Michael Liner's videos, learn from that. There's a lot of people out there who know what they're doing. And, you can learn from anybody. I mean, you may not apply what you learn. You may not find it was relevant to what you do, but the more knowledge you have, the better. So absolutely learn from whomever you can. Have a great evening. I will do so. It's in the Eastern time zone, it's 10:06, so it's getting kind of late, but okay. I have 3 hearings tomorrow. Tomorrow's going to be a very, very, very busy day. I have hearings, let's see, at 10:45, at noon, and at 2:30. So I'll have a long day. Hopefully we'll go 3 for 3. That would be really, really nice. And then next week on Tuesday, I'm speaking at a seminar, a lawyer training seminar from 11 to 12. And then I've got a hearing at 1:15 and a hearing at 2. So my 1:15, I hope is on time because the 2 o'clock starts at 2. So I got a busy few days here coming up. So, but I'm Mrs. B. I'm glad that you were able to stop by and check me out next week. Or subscribe, even better. Subscribe like Christina suggests, and you'll get notified. The dude says it's starting to cool down here in Vegas. Okay. I mean, today here in Atlanta, I played tennis this afternoon. It was a really rainy, cloudy day, and then we got lucky at about 3:30. The skies cleared, it dried up, and we got just drizzle a little bit, but got a set in, 2 sets in, and had a nice chance to get a little bit of exercise. So, but it's supposed to rain in Atlanta. It's supposed to rain tomorrow, Friday and Saturday and Sunday. And I have a scheduled a league tennis match, Alta, which is like USTA. It's the tennis organization that sanctions the matches. So I've got a match, and I'm the captain of the team. Got a match on Saturday, but it's going to get rained out, so we're going to have to make it up, and it's a nightmare. But anyway, Rex says, "Thank you for answering my question. That's what I'm here for." Okay, dude. Wake up, American, resist. Hello, sir. I'm 63, and I've been an SSD since 92. Switch over to retirement. I mean, they'll switch you over automatically. So it's not a matter of you doing anything. They'll switch you over automatically. Okay, get a case evaluation. And also do not forget to put in a review. If you would not mind, I would really appreciate that. Okay. Paula says, I dropped some form for my case in the SSA office. Next day, I already received it. How long to review it? It's how busy they are. I mean, it could be, a week. It could be a couple of days. It just depends on how busy they are. I mean, they have adjudicators or case analysts have a certain number of cases they're responsible for. So it just depends on how quick they get to it. MT, I got an attorney, applied for SSD and SSI. Can you prove both get paid? No, well, let me answer this. You get the higher of the two. The only time you're going to get, if you have SSDI and you get SSI, if during the 5-month waiting period, you might get SSI. Those 5 months or 6 months, you might get a past due payment for that. But then usually, unless your SSDI is really low, it's lower than the SSI, which I think was 983, you're going to get only one. You don't get both. You don't double dip. Okay. Michelle, my hearing was on the 25th of September. My attorney does not feel it's necessary to prep me with questions. I had another attorney for an hour to prep me. If any appeal could deny further options. That is weird that your attorney does not feel necessary to prep you, but you hired somebody to do so, which is smart. If your appeal gets denied, you can appeal to the appeals council, but it's not like they're going to revisit the ALJ decision. They're going to look to see the judge make an error of analysis. Like, for example, if the judge, wrote in his decision, I looked at the last 15 years of work and concluded that Michelle could work, a job she did 7 years ago. Well, the look back is now 5 years. That's an error of analysis. If you're, 55 years old and you have physical injury and the judge does not look at the grid rules, that is a reversible error. If the judge, if there's evidence in the file of, let's say, radiculopathy radiating pain into your leg, and the judge's hypothetical does not include that, that could be a reversible error. That's the sort of thing where you can get the appeals council to remand it if it is determined to be, substantial and significant error. Okay. All right. And here are these, we can get free functional capacity forms there. There's a couple places you can do it. One is there and one is there. So yeah, I think that there are some good places in the chat here. So you have to write it down, but it's very helpful if you want to use those, because that does translate your medical issues into work limitations. Okay, a YouTube user. That's pretty generic, but okay. People, look, you got to be careful these days. I've had 3 attempts unsuccessfully to ask your doctor to complete your functional capacity form. Only if you did surgery. How do you overcome it? You can't. I mean, if the doctor won't complete it, you may need to go to another doctor. Nothing you can do. I mean, you can try to talk to the doctor and say, look, I need this for disability. And, sometimes doctors are suspicious of people applying for disability because they think they are, trying to game the system. So maybe you just need to talk to the doctor. Maybe you have to offer to pay him. You offer to pay him $300 to do the form. Maybe he'll do it. But there's no way to force a doctor to do that. And, he's got defensive when again, you may just have to find another doctor, or maybe write him a letter and just say, look, I'm not asking you to do anything, improper. I'm just asking you to make comments on these things, but, you can't force him to do it. Glutenless Sin City. So I'm assuming you live in Las Vegas and you do not eat gluten. I went to school. You're a female Gulf War veteran with PTSD and you have DJD, degenerative joint disease of the spine, and you're a trucker waiting for the VA for your rating. Okay. I've talked about this before. PTSD in the military is hard. You may not find it as hard getting a VA rating, but Social Security, for whatever reason, I don't know if they feel like because somebody's getting the VA benefits, they don't need to pay them Social Security, or they feel like, anybody who goes to the military, should expect there'll be some traumatic events, or maybe they just feel like the VA records are not clear enough. I don't know. It's just hard. It's hard. I always tell people if you can get to an outside source, that would be helpful. And I told the other gentleman earlier, keep a diary of symptoms, get statements from other people who've observed the problems you're having. Talk about, specifically what triggers your PTSD. And that could certainly help. The degenerative joint disease of the spine, is something that's more objectively determinable. So you can get an MRI of that. You can see that may be a stronger argument, depending on how old you are. That could be a stronger argument than the PTSD alone. I think the PTSD at a minimum would add to a back pain case. If the PTSD is really, really severe, it might hold it on its own. But again, the question would be, you've been a trucker, you're still driving a truck with PTSD. Driving is stressful. You're going to have cars backfire. You're going to have, people slamming on the brakes, just honking the horns. So, the PTSD is a little inconsistent with that. Maybe that's where you're stopping work. I don't know, but I still think that back pain is going to be because it's objective, is probably very possibly a stronger argument. Um, and Afghanistan hey, I do not disagree with you that Afghanistan for 3.5 years would do it. Some judges don't seem to get that. Look, everybody who served, I take my hat off to you. I applaud you because it is. I've talked to enough clients that tell me the stories of just being under constant stress in fear of your life for months at a time, and it changes you. You see your best buddy blown up. You see a little child blown up by a roadside bomb. It's going to change you, not in a good way. Um, the VA does what they do, but they have limited resources. And I think people come back and they don't necessarily get the treatment they need, and it's really a shame because people that served our country, you know, are being asked to kind of deal with this alone, and it's just not. There's some statistic that I don't know, 30 or 50, some large number of veterans commit suicide every single day, and it's extremely disconcerting to see the way not just the VA but Social Security treats them. So. Um, Okay, now Sin City, you are driving. You said I'm a trucker. Okay, so you are not driving anymore, I'm presuming. Um, yeah, I just think you want to really focus on the symptoms. Does the lack of a VA rating? Okay, does not hurt you, not at all. You tell them that you are um, that you are expecting a VA rating, but it's not binding on Social Security anyway. Well, Sarah, you just did post your question. You post this question, so you can do it through Facebook or through YouTube, either one. But you just did, so wherever you just did it, do it there again. Sam has Sam has facial paralysis, both sides with trigeminal nerve injury, lots of pain, bipolar disorder plus back arthritis. I have not had a ton of success with trigeminal neuralgia. It is very painful as I understand it, but I just don't seem to find that judges tend to like to approve on it. I don't know why. The bipolar, again, if it's well documented as being really serious and it's caused some significant problems, that can help. The lower back arthritis, but again, you have an MRI that shows something really, really significant. You could argue all three of these, and that would be something to do. Obviously, it depends on how old you are. If you're over 55, it's going to be stronger. But I will tell you that trigeminal neuralgia, really hard to win on those. Bipolar, unless you are, again, inpatient hospitalization or suicide attempts or multiple failed medication trials, you need more than just a diagnosis of bipolar. And lower back arthritis, it's got to be, impinging on the spinal cord. It's got to be significant. All right, so Sam is 54. So that helps a little bit. Maybe you can get a grid rule argument if you're limited to sedentary. You can argue the grids. So, again, it's better that you're 54 than 34, but still an uphill battle. Cancer-free. Someone, and I don't remember what you wrote before about somebody abandoned you. I'm sorry, cancer-free. I'm going through these as quick as I can. I don't know if you're talking about your spouse. Oh, your spouse, whether you can claim on his record. If you're not divorced, that's an interesting. If he's deceased, maybe. If you're divorced, maybe. I don't know that you can do so if he's still living. I don't know. Do I think they'll ever get rid of the grid rules? I hope not. I won a lot of cases on the grid rules. I really hope they do not. There was some float that was floated a couple of years ago, but it has not gone through. So could they tighten them up? Yes, but right now it doesn't look like they're doing that. So I don't think that's going to happen anytime soon. I hope they don't. Okay. So Eric, Dee Dee wanted to know, or Eric wanted to know how to get those estimated monthly payment. Dee Dee says call your local office. Good luck getting through, but call the office. Um, okay. All right. So Rebecca's the one who got approved at initial, but got denied at a hearing. 32. Um, so, obviously the letter from your psychiatrist really made a big difference. So, look, I'll tell you, 32 to win on PTSD, that's rare. So, not that you want to give up past due benefits, but you got very fortunate. Let's put it that way. Not that I'm doubting what you're going through. I'm just saying it's the profile of a 32-year-old person with a mental health condition winning. That it doesn't happen that much. Um, um, Yeah. You're in a tent with oxygen. Um, you know, I don't know how you find out if you knew his social security number. I just honestly don't know off the top of my head whether you can claim on his record. If you became, if he's deceased, I think you possibly could as a disabled widow. But if he's not, if you don't know if he's deceased, that's a question. Can you find out if he's deceased or not? Or if he divorced you, that could be another thing too. Um, um, all right. GC Stiles talks about the weight of evidence, the treating source rule. That's what you're talking about. That's when Social Security said that a treating source used to be had to be given controlling weight, and they changed that. I mean, it says 2000. I don't remember when it was, but let's say 2016 sounds about right. Then they basically said you could have any doctors. The judge could rely on any doctor, and GC says I feel all claimants are denied should get a do-over, and unfortunately, it's not going to happen. That's one of the things that O'Malley did talk about was the treating source rule needs to be revived. He basically said that was sort of phase 2 or 3 of what he hoped to do. So I'm hoping that will happen. Okay. We got about 10 more minutes to go. Mrs. K says, I'm still in recon, be 54 in a few months, had 2 epidurals. Somebody's quad came for stability. Yeah, I think that's a good case. I think that you've got a pretty good argument for being limited to sedentary work. You got numbness. So, I would argue, look at the grid rules and argue the grid rules. Okay. Jim, okay. Jim, I'm obviously not going to use your name, but he is the person that, Jim is my client, that the CE doctor put his socks on and is excited for his hearing next Tuesday. Well, I think we got a really good case and I think we're going to win. But yeah, we were talking about that. We were looking at the CE report and Jim was like, you got to be kidding me. Because she helped me off the table. She helped me put my shoes and socks on, yet she's saying I had no problems getting off the table. So I may ask him about that at the hearing. We'll see. But thanks for tuning in, Jim. Good to talk to you today. Okay, Ms. B. How to pose my question. My situation seems complicated. I've seen several specialists and diagnosis still not concrete. There may be more to this question, but I'm not seeing it. I have cervical radiculopathy, adhesive capsulitis, severe pain from neck to fingers. Now specialists about CRPS. Okay, CRPS is chronic regional pain syndrome. It's kind of a chronic pain condition. It is complicated because it's hard to prove, but cervical radiculopathy, that's going to cause numbness and headaches and things like that. Adhesive capsulitis is going to make it hard to use your arms. I don't know how old you are. Again, the grids could come into play if you're over 50, but if not, you're going to argue functional capacity. I think you have to just argue all the things that these, CRPS can be really, really deadly. It can be really painful and just really, really hard to live with. So I think you need to probably see a pain management person to help, document that a little bit better. Tree saw limb na birch. I have fibro. Do you think a person ever said pain? I've won them before. You need to have a rheumatologist in your corner. You need to have a rheumatologist in your corner. I think it's really hard to win. There's something called the American College of Rheumatology that has a fibromyalgia criteria. and you need to meet that criteria. Social Security does recognize that fibromyalgia does exist, but you got to have a lot of medical evidence to win. But yes, you can win. It's just really hard. In other words, the way I would look at this is fibromyalgia is something that for many years doctors didn't know what else to call it. They'd say, you got fibromyalgia. So you got these sort of, family doctor diagnoses of fibromyalgia. Then you've got a whole other category of people that have gone to a rheumatologist, that have had trigger point injections, have got all the different, have tried Lyric, have tried all these different things. That's sort of another category. You got to be in category 2, not in category 1. You can't go to your family doctor and say, my family doctor says I got fibromyalgia, I'm disabled. Now you got to go through the ringer. They got to go through all the medication trials, the pain things to deal with the pain. So I think it's tough. You did not get a copy. Yeah, you should be able to get a copy of that. You could contact the office and make an appointment and say, I want to get a copy of my file, or get it on CD. Yeah, you should be able to copy that, Sarah. See why you shouldn't. Okay, Ms. B had CRPS from a car accident. I've been able to work since July 24, not flying. Again, I think it's just a matter of what the medical evidence is going to show. Do you have support? But I think if you're arguing CRPS pain management, you need to have a specialist. You can't just use a family doctor. And really, I would almost tell you in a situation like this, CRPS, get a functional capacity evaluation with a physical therapist. That will provide direct evidence of your capacity. Okay, 5 more minutes to go. Jen put our YouTube channel in there, at SSD Attorney, youtube.com @SSD Attorney. We see with YouTube, you can choose these, you can choose your channel names. So I had Ginsberg SSD, or you can do the @SSD Attorney. So a lot easier to figure out than the long official name, as it were. Is SSI going to hire more staff? Only if they get more money from Congress. That's that problem. Okay, that's the same as Mrs. B. Okay, so we got Ms. B and Mrs. B. Ms. B has cervical radiculopathy, and I apologize if I confused the two of you. You don't have CRPS, I'm guessing. Cervical radiculopathy. Oh, you do have CRPS. Okay. Ms. B has CRPS and cervical radiculopathy. I just think that it is. It's going to come down to, can you get functional capacity forms? Can you get a functional capacity evaluation? Do you have strong support from your doctor? Those are the things you're going to need, because, unless you have an MRI that shows, major disc problems, anything else is going to seem inconsistent with the objective evidence. By definition, CRPS, you have objective evidence that shows, let's say, a mild accident of some type, and mild disc bulge, but you have pain way out of proportion to it. You're going to have to convince your doctors that that's legit, and get I think a functional capacity a report from a physical therapist would be helpful. Thank you. I hope they're successful too, and I know that Jim hopes we're going to win Jim's case. I'm pretty confident of that. What happens if they cash in taxable assets? Not for SSDI, yes for SSI. The volume is low at times. Okay, thank you. I'm going to work on a different microphone for next week. Sometimes it's the internet connection. I'm a wired connection here, but I'm using this microphone, and I'll put it up a little bit higher. Hopefully that's a little bit better. I'm trying to, I'll work on that. I actually got a new webcam that I didn't get hooked up yet. That hopefully this is pretty good, but hopefully the new one will be even better. Or maybe I'll use 2. And then I'll work on a little different microphone too. Okay, you're welcome, and I'm glad this has been helpful. Just got approved for SSD at 63, no CDR dates. You won't have a CDR because you're close to retirement age. I just think, plus you're not going to have one. I just think it's really unlikely. Son gets dependent benefits. He's 18. We received a letter saying benefits will continue, graduates. No funds will be sent to a financial institution. Okay, yes, I think that as a dependent, you will continue to get auxiliary benefits while he is dependent on you. No funds will be sent to, I think that means that it's not going to be sent to, I don't know. That's a good question. What is that? I don't know what that means. Financial institution. Um, I don't know. I don't know what that means. That's bizarre. I don't know what that means. I wonder if Greg Brinkley might know. Check. I would email Greg. He'll answer your question. Greg at gregbrinkley.org, GREGBRINKLEY, Greg at gregbrinkley.org. He could probably answer that question. I don't know. He used to work for Social Security. What does it mean when a caseworker says, "What bank do you use?" They want to make sure they've got. I would say probably a good sign, and it does. It means they want to make a deposit. So hey, somebody wants to make a deposit. That's good. So I think it's a good sign. Will they raise yes, they have raised it to $9,200 as of the 1st of December of this year. So it was at $6,000 for like 15 years. They raised it about 3 or 4 years ago to $7,200, and they're going to raise it again to $9,200, really just to keep up with inflation. That's another reason why I like Martin O'Malley, because he helped put that through. Look, attorneys like me, we choose to do this. You don't get rich doing Social Security disability. The fees are capped. Obviously, $7,200. Cases, if you don't, you get a bad judge, you get nothing, or the case gets approved early, you get little or nothing. They're not going to be a lot of $9,200 cases, but I'm not apologizing for what I do. I mean, nobody has to hire me if they don't want to hire me. I think that attorneys like me, we add value, and so yeah, that's it's like you don't get capped in workers' comp, you don't get capped in personal injury. We get capped. So this is just a way for us to get a fee that allows us to stay in business. And I will tell you, again, I'm not poor mouthing or anything like that, but it's expensive to run a disability practice. These cases take 2-3 years to go through. You've got a lot of people, a lot of phone calls to answer. I get people that are upset because I don't call them every time something happens. We try to use email or text, but some people want to get called all the time. Can't do that, $7,200 a case. And really, it's really more like, average is about $4,000 a case. Just can't do it. So the higher fee cap will allow me to provide better service. And it also, allows, attorneys to stay in practice. And again, I'm very fortunate. I have a great staff. I have good cases. But, some people have a lower approval rate than I do. They don't have as good a cases. It's hard to stay in business. So, yeah, I'm happy for that. Ms. B is so the grids Ms. B will not apply to you at 48. So I think, again, I still stand by get a functional assessment from a physical therapist. Okay. I'm going to go with a couple more of these. Meniere's disease in both ears. How was it denied? It's a listing. The listings, they make them really, really hard to meet. And Meniere's disease is one where you have balance issues. And you'd think if you meet a listing, you would win. But, if you look at the listing itself, it may be requiring certain testing or something that you didn't have in your record. It can be very, very specific. But other than to say other than say it's just Social Security. I could 5 or 7. Okay. Ken says there's no CDR date in there. There actually is a code someplace. I would reach out to your Social Security office and say, I need to know if this is a 7-year review, because I want to apply for student loan relief, and see if they will provide that to you. And I think that's a very good reason to get that. Okay. All right, Tammy, watched you for a long time. Second phone on getting disability, along with nothing is serious. Well, that's you need to have something serious and severe. So that's a problem, because if it's not severe and serious, it's going to be hard to win. Can you discuss federal taxes at the end? I will tell you the best way to deal with SSDI and taxes. There are a number of good articles out there. And the IRS has something here. I'll put this in the comments, and it's just a matter of household income, but that is the answer to that as far as taxes. Let's see. Okay. And T-Cash just approved, was held to low call for 6 months. Call them if they just said hello. That's the Social Security. Yes. Had my money in 2 days. Yeah. Sometimes stuff gets stuck on somebody's desk. Hello from Chickamauga, Georgia. I'm not sure where Chickamauga is. I probably have passed through it at one point or the other, but hello. I'm going to take two more. All right. Michelle, I had my SSD hearing on 17th of December. We're in 27 months so far. No returns, I'm too young. 32 are my chances to win. 32 is really young. That's the problem, is that, the odds of winning are not great at 32, unfortunately. And attorneys get paid in contingency. And, like I said, if we don't win, we don't get paid. So that's the problem. It's hard to get an attorney when you're that young, unless you've got something overwhelmingly severe. And, if it's mental health, it's really hard. So I sympathize with you. I remember at the convention, somebody floated the idea of, they should offer attorneys higher fees for the more difficult cases, the younger claimants, so they get attorneys. But again, no fee unless you win. If you don't think there's a good chance at winning, you're going to want to spend a lot of work getting a case worked up, only to have it turned down because the judge says you're too young. Okay. Okay. So last question here. Okay. Chickamauga, I cannot find info on Social Security and optic eye stroke. Loss of vision and criteria for claim. I think vision cases, there is a listing that addresses vision cases. And I would look at that listing and see if you can get your ophthalmologist or your neurologist to say that your condition functionally equals the listing. And that is really what you want to find out. Or you could argue functional capacity, that because of this optic eye stroke, you do not have the vision that will allow you to work at any type of job. So I'm not sure that optic eye stroke is a listing level condition, but you certainly could argue functional capacity. Okay. Okay. Last one, CC says, you spoke to my call screeners. I just got somebody new I added to that. So we'll be, again, we get a lot of calls and I have really good staff, but I had one call screener that worked with me when I couldn't make the calls. I now have a second. And again, that's additional salary, but we got to do it. So that's again where the higher fee will come into play. So you should get calls back and I'll make sure that gets followed up. Okay. How do you find if you're still married? I mean, I would say if you knew what state, you could certainly look at the general execution docket for the state you're in or the state you think your husband might be in. I don't know otherwise. You could hire a private investigator. You could stalk him on Facebook. You could check with his relatives, but there's to doing it where it's free. That's going to be hard. That's going to be hard. His Social Security number, but not any more than that. I mean, you could certainly try to argue. You could say to Social Security, I want to pursue a disabled widow case or a disabled widow's benefit case or a benefit case on the ex-spouse's earnings record, and give them the number and see what comes. I hate to do that because you deal with Social Security numbers and you don't want to do anything that's going to be improper. You might even talk. You know what? I would say this: email Greg Brinkley. He might have an idea about how you do that. Greg@gregbrinkley.org. Greg@gregbrinkley.org, and just see what he says. I don't know. That's a very good question. Okay, it is now late in Atlanta. It's 10:38, so I'm a little bit over. I like to do these for a couple hours. So again, I'll be here next week. Let me just double check that. I'm pretty sure I'm on Wednesday next week. And then the following week I'll be here on Wednesday. And then on the week of the first week in October, I'm going to do it probably on a Tuesday night. So anyway, I'll keep everybody informed, but the next few weeks I'll be Wednesday night. I hope everybody found this useful. I appreciate your questions, some great questions, some really nice comments. Thank you very much. Again, if you are inclined, leave me a favorable review. I would really appreciate that. And, again, just type in Ginsberg Law Offices and you can, get to the Google review page. Go to avo.com, avvo.com, and you can review me there. Really appreciate that. Thank you all. And again, I'll work on the microphone and we will do it again next week. So everybody have a great weekend. Stay safe out there. Stay, I guess now it's cooling down a little bit, so it's not going to be a real hot type of summer at this point anymore. But everybody stay in the best of health, and we'll talk again next week. Thanks a lot.